The Fed Upward Podcast, a place for federal employees and friends of feds to find strategies and tactics to navigate everyday problems.
And now, a quick word from our sponsor.
3, 2, 1.
From launch pads
We have liftoff.
to research labs, civilian Fed life leads to many places, all covered by WAEPA. WAEPA offers fully portable group term life insurance for current and former civilian Feds. This coverage answers whatever life brings, with benefits that follow wherever service calls. WAEPA. For Feds, by Feds.
Hi, folks. This is Love Rutledge, host of the Fed Upward Podcast, here with former Fed Courtney Mickman, who was formerly an attorney working on issues that I think you will want to hear about. She has transitioned to the private sector and has some thoughts, observations that federal employees who are still in their jobs might find helpful. Courtney, thank you for coming on the show.
Thank you for having me.
So first, let's talk a little bit about your federal career and the type of work you did for the EEOC.
Sure. So I am an attorney. I've been practicing since 2012. I joined the EEOC Washington field office in 2018 as an administrative judge. At the time, there had been a quite significant backlog of cases. There had not been hiring of administrative judges in a few years. That's a position that does not have automatic backfill authority, even when there's no hiring or hiring freeze in effect. I held that position for about 6.5 years, though I did a detail to the EEOC's Office of Federal Operations at the end of 2024. An OFO, It has several functions, but I worked within the Appellate Review Division, which decides appeals of final agency decisions. And those final agency decisions are issued in various circumstances, including after an EEOC administrative judge has issued a decision. So I was working on decisions that are various kinds of appeals, including appeals of my colleagues' decisions. I stayed in that detail until I left EEOC in March 2025, which is when I began working as senior counsel at the law firm Allen Lesh and Associates, which is a boutique employment law firm here in Washington, D.C., where I advise and represent employees at all levels from GS to wage grade to SES, along with private sector employees.
Thank you for that. So you've seen Equal Employment Opportunity Commission related issues from both sides, right? Inside government and outside. I want to remind our listeners that the EEOC enforces laws that make discrimination illegal in the workplace. I think most people are pretty familiar with what the EEOC does, but I just wanted to put that out there in case folks needed a refresher. So, Courtney, just tell me a little bit about the ins and outs of EEOC cases and things that folks might want to keep in mind if they're either filing a complaint or they have had a complaint filed against them. And before you jump in, I want to say this is not official legal advice, guys. Always consult your own attorney when you're facing challenges like this.
Sure. So I guess it would make sense for me to start with what is an administrative judge and what function do they actually have? And
Yeah, please.
An administrative judge is a finder of fact. They're attorney examiners whose job is to ensure that the record on the complaint is fully developed. Administrative judges determine whether disputes of material fact exist and then make findings of fact and credibility, which sometimes necessitates a hearing, but not always. And the idea of this administrative hearing, it is quite similar to a trial in a state or federal court, except there's no opportunity for a jury. And then the federal rules of civil procedure and evidence, which are used in federal district courts, for example, those are really just guidance at the EEOC, and there's no requirement for administrative judges to strictly adhere to those rules. Instead, administrative judges focus on the facts of the case as well as governing case law, which includes Supreme Court precedent as well as the precedent set by EEOC's Office of Federal Operations. And EEOC has jurisdiction to resolve and adjudicate claims of federal employees. Those are specifically claims of discrimination and retaliation, but that's only types of discrimination that are protected by specific laws enforced by the EEOC. So that includes Title VII, the Rehabilitation Act, the Age Discrimination and Employment Act, Equal Pay Act, GINA. The EEOC does not have jurisdiction over all kinds of discrimination and retaliation. For example, if you're hearing about whistleblower retaliation or FMLA retaliation, those are not claims that would be proper before EEOC. Similarly, discrimination based on something like marital status or veterans preference, that also would not be appropriately at the EEOC. We're talking really just claims of discrimination, harassment based on race, sex, national origin, age, disability, religion, and reprisal for engaging in protected EEO activity. And so administrative judges have the authority to decide whether a federal agency engaged in discrimination or harassment based on those specific protected characteristics. And where discrimination is found, administrative judges have authority to order remedial action, which can take the form of reinstatement, back pay, rescinding discipline, restoring leave, paying compensatory damages, reimbursing attorney's fees, litigation costs, posting a notice that discrimination was found at the particular agency, requiring training of responsible management officials, and of course, ensuring an employee isn't supervised by someone who was found to have engaged in harassment or discrimination.
Yeah, thank you for that rundown, Courtney. And I hope that as folks are listening to this, if they are current federal employees, this is sounding very familiar because we all have to take annual training on some of these issues. But I appreciate you going through what an administrative law judge does in these kinds of cases, because that's a side of things that we don't get any training on or quite understand how the mechanics work when these cases are adjudicated.
Right. So, in terms of issues that we are seeing at this point, or in light of the change in the administration, I think that there are a number of issues that employees at all levels really need to be mindful of. And, that goes for employees that maybe think that they're suffering from discrimination, but also managers who may be in a position to see something, say something, and put a stop to an action that could be problematic for the agency. And I think that there are a number of different kinds of issues that are being raised right now that are very specific to the change in administration that are not necessarily partisan issues, but they're coming to light now based on certain issues as part of the administration's agenda, which, the big one that everybody is talking about here in DC, at least, is the return to office mandates and the impact that that is having on employees. And that really is having an impact in a number of different ways. The biggest issue that I'm seeing with my EEOC hat on, looking at the issues, is that there is very little consideration being given to employees who have disabilities and medical conditions that are protected by the Rehabilitation Act, that have perhaps been teleworking for a number of years, pre-COVID have had telework, and now due to the return to office mandates, they're unable to get the telework that they need as an accommodation, or they're having their accommodation revoked, being told to resubmit. And there's so many people right now that are putting these requests in at a time when attrition is at, all-time high, And that is contributing to the slowdown and delay in employees being able to get their accommodations approved. And,
So,
there's just the general sentiment that employees should be in the office working.
right.
And now, a quick word from our sponsor.
ClearanceJobs, the leading digital network for cleared professionals, has launched fedwork.net, connecting federal employees with news, insights, and community. The public forum serves as an extension of the ClearanceJobs career community, empowering feds to stay connected and informed. Visit fedwork.net to search and start discussions, and create a free profile at clearancejobs.com to find your next cleared role.
And Courtney, I want to take a step back because you hit on a really important point as the return to office mandates are being enforced. Folks who maybe have not had to seek reasonable accommodation in the past because they had telework agreements that kind of gave them the accommodations that they needed unofficially are now having to go through that reasonable accommodation process, which can take a long time and requires seeing a doctor, getting confirmation of whatever your, reasonable accommodation is that you might be requesting, supporting documentation, and then sending that through your agency or department's administrative process to adjudicate that. And so that can take some time. And for folks who are caught in that waiting time, they're having to return to the office, and that can be quite a struggle. I want to make sure that I've characterized that appropriately. Is that sort of the administrative do loop that we're talking about here?
Yes, that is a majority of the issue. The other piece is that there are some agencies who they have not taken into account the medical needs for teleworking. And so there is a much higher level of scrutiny on those telework accommodation requests than we have previously seen. And, for employees in particular who they have demonstrated their performance over a number of years, having worked from home with the accommodation, it is concerning to see for those individuals in particular that are now having to maybe exhaust a lot of leave or go out on FMLA leave while waiting for approval. And typically, agencies do have a policy on an interim accommodation, which is something that the law requires that an individual would receive an accommodation in the interim while a final decision is being made. However, some agencies have imposed very short time limitations on that interim accommodation. And so the reality is that in addition to the fact that employees may be having to go get medical documentation and submit that to various individuals, sometimes duplicates, and, go back and find records where their agency has already approved an accommodation 5+ years ago. Now we're seeing that there's just additional barriers to the process, and the interim accommodations are sometimes for only a short 10-day window when the process typically takes months to get approval. Some agencies do have time limits on how long they set to issue a decision, for example, a 30-day time limitation, but maybe that time allotment was more realistic in a different time period from now. But again, now when there is this rush of employees that are all filing at the same time at a time when maybe the individuals that are processing those requests, there's less of them now due to attrition, it's creating a very long wait time.
What advice, if any, do you have for folks who are in that boat, who are maybe exhausting their leave, who tried or maybe have already run through that interim accommodation time period? Anything that they should be thinking about or doing to either expedite the process? I realize it's out of their hands, or anything that they should make sure is in their package that won't slow down the process?
Sure. So without giving legal advice, I'm just going to generally say there is a certain level of documentation that agencies are entitled to when when an employee makes a request for a reasonable accommodation. So certainly submitting a request without medical documentation is going to slow down the process. Making sure that your package includes the requested documentation, that is helpful. Keeping your management chain, your supervisory chain in the loop on what is going on, that and what your needs are, especially if perhaps you have needs that are changing. That is helpful too. But again, most of what we're seeing now, while first, second level supervisors were a little bit more involved working with a reasonable accommodation coordinator prior to this administration to be involved in that accommodation process. Now we're seeing that the accommodations are being approved at a much higher level, completely outside that chain of command. So keeping your supervisor in the loop is helpful to make sure they know, are you going to be working? If you're not going to be working because you're out on leave, who's going to cover that work? You want to make sure your manager is involved in that sense. But there's only so much that first, second line managers are really able to do now. But depending on the amount of time that individuals are waiting and whether or not they're being accommodated in the interim, or if they're ultimately being faced with the decision of exhausting leave or even taking leave without pay or going out on FMLA. Those are personal decisions that everyone needs to make. And if employees are looking to preserve their right, then what we're seeing a lot of our clients do is file an EEO complaint once they are at the point where they've requested the accommodation and the interim accommodation runs out. That way, they end up waiting a significantly long period of time in order to get their accommodation, or who knows, it could end up getting denied in the end. Then at least preserving your right by pursuing the EEO complaint in a timely manner. That is one thing that we're seeing a lot of employees choose to do.
I know every case is different, but how long does it generally take an EEO case to kind of make its way through the process to get to the point where a decision is actually made?
That's a good question. So it's really a two-part process. There is the, administrative exhaustion within a federal employee's own agency. And that part takes at least 7 months, and it could take longer. Employees initially go for EEO counseling, which is a 30-day window. It can be extended to 90 days if the employee elects alternative dispute resolution or mediation. And then when they file the formal complaint at the end of that informal pre-complaint counseling period, the agency is then obligated by regulation to investigate the complaint and issue a report of investigation, which that report does not decide whether discrimination occurred, and it instead just provides evidence so that a fact finder can make a decision about whether or not discrimination occurred. Once that report of investigation is issued, an employee has various options about how to proceed, one of which is to let the agency issue a final decision. So the agency will decide whether or not it engaged in discrimination or harassment, or the topic we're talking about, whether it failed to accommodate an individual's disability. Another alternative is requesting a hearing at the EEOC, where the employee can then have the case heard by an administrative judge. Another option would be to just go right to federal district court. And many employees do request a hearing at the EEOC, which again is very similar to the process in a district court. It's just the rules are a little bit more lax and there's no jury trial, the rules being the federal rules. And so that process at the EEOC, that can take a year and it could take longer. It really just depends on the nature of the case, how much evidence the parties request, and the nature of the requests, whether they result in disputes that could lengthen the process. And typically, if you're seeing a case that has a lot of claims in it, that's going to take a little bit longer to process because there are going to be more witnesses. There tend to be more documents related to that kind of claim, a claim that has more issues in it. So if you're talking about a single issue case, like one claim of failure to accommodate, that can be adjudicated much faster than a claim of hostile work environment that has maybe 30 to 40 examples of harassment in it. You're going to have more evidence, more witnesses. If the case goes forward to an actual hearing, you're going to more likely than not have, witnesses testifying to each of the events. And it can take longer to adjudicate simply because there are more issues.
That makes complete sense. And again, the answer is it varies wildly depending on the complexity of the case, how long the agency or department is taking to move forward. So I appreciate you going through that rundown of the possibilities of kind of the decision tree, right, on how things move forward with these cases. One thing I wanted to touch on before we wrap up is kind of the difference between the diversity, equity, inclusion mandates that we've seen recently and EEOC law. So just want to throw out there that regardless of diversity, equity, and inclusion policies, EEOC law is still enforceable. Any thoughts on that or clarification you might want to provide for people who could potentially be confused about that?
Sure. And I do generally think that there is a lot of confusion on that topic. I see things regularly in the news and even in OPM guidances and various other documents that demonstrate there is confusion throughout the government, but also, even in the private sector on this topic. The EEOC, it is still there. The laws that it enforces are still active. They are unrelated to the idea of diversity, equity, and inclusion policies. For many years, it is and has been unlawful to hire based on any protected characteristics such as race or sex or religion. That has not changed at all by the creation of DEI programs or the elimination of DEI programs. That is something that it is unlawful through Title VII. And so we are seeing a lot of confusion about that. And it is important that everyone understands, it is unlawful to, and it has been unlawful for many years to select someone for a position based on their race or sex, to take any kind of employment action, to fail to take an employment action based on someone's sex or race or national origin, religion, disability, age, or for engaging in any kind of protected EEO activity.
Great. Thank you for that clarification. I really appreciate it. Courtney, is there anything that we haven't touched on today that you think federal employees should hear?
I think that I will just add that there are a lot of resources out there. Certainly there is no shortage of attorneys, but even separate from hiring an attorney, the EEOC does have great resources online. They do issue official guidances, which are on their site. And while they do include legal citations, they typically include a Q&A section with easy to understand fact-specific scenarios that are relevant to common issues that employees face and employers receive regularly. And those resources are, again, not just for individuals that think they may want to file a complaint. They can also be a resource for managers. And especially right now where we are seeing large-scale attrition across the government, to include employees that are in HR and labor relations, the RA office, even counsel's office. If managers aren't getting information they need in order to respond to concerns raised by employees or just general concerns that they have, there are resources that managers can consult that come directly from EEOC. And in addition to those guidances that I mentioned, there's the EEOC Management Directive 110, which is helpful to learn about the EEOC federal sector process. And then, of course, law firms have blogs that include tons of resources. You can find my firm's blog at www.dcemploymentattorney.com/resources/blog/ There's lots of information there for feds that are interested to know about all kinds of issues. I know we haven't talked about the big topics, the big elephant in the room, which is RIFs. That is something that is really, really big right now. And our firm has a lot of resources for employees to find on that. And so, yeah, I think just trying to know the right thing to do, it does take doing a little bit of due diligence and reading to make sure that employees know what their rights are, but also so that employers understand what their responsibilities are as well.
Perfect. And, for folks who are looking for those EEOC resources, the website is simple and easy to find. It's eeoc.gov, and I'll make sure I have the links that you mentioned, Courtney, and that one in the show notes so folks can find it. As always, I'm not endorsing any particular attorney or set of legal advice on this podcast. I'm not being paid by Courtney's employer. So I just want to remind folks that this is just a free resource to help steer folks to find the additional resources that they might be looking for. And Courtney, thank you so much for giving your expert advice for people who are looking for that information, again, from the perspective of someone who's been on the inside and the outside. Courtney, thank you so much for your time.
Thank you for having me.
Thanks for listening, friends. If you liked what you heard today, I hope you'll subscribe to the podcast and share it with a friend. To join my mailing list, head over to fedupwardcoaching.com/podcast. Talk soon.